We are going to get started with our session on unpacking and rethinking guardianship for disabled people.
Hi, I'm Larkin Taylor Parker. I'm the legal director of the Autistic Self-Advocacy Network. I should preface this by saying that I am a lawyer. I am licensed to practice law in North Carolina. I'm not your lawyer, and I will not be giving you legal advice. What that means is applying the law to the facts of a specific situation. If you are in need of legal advice, if you have a situation where you need specific and individual application of the law, where the situation is unfolding, to a set of facts in the lives of real people, I highly recommend that you talk to someone licensed in your jurisdiction. And I don't know everyone out there, but if you're having trouble finding someone, feel free to send me an email. And if there's any way I can connect you with someone and make a recommendation or a referral for you, I will. I didn't bring slides. I want to keep this as conversational as possible. I welcome questions and comments during and after. Please raise your hands. Do want to flag for you that unfortunately today is just packed for me. Wasn't able to join quite as early as I had hoped, and I have to go at 3 on the dot for another meeting. So let's not hold questions or comments until the end, because I really can't linger past time today. Please pardon my allergies. It's been a really bad allergy season here. Can't be helped. So let's start by talking about what guardianship is. Guardianship in pretty much any US jurisdiction, and there are a lot of state-specific nuances here. This is where it becomes so important to get advice from someone in one's own jurisdiction about specific situations. But in pretty much any US jurisdiction, what guardianship is taking one adult, in the adult context, is taking one adult's legal decision-making authority, the basic authority that most adults in American society have outside of special situations like maybe prison or the military, to make decisions about our own lives, taking it away from one adult and giving it to another adult. Sometimes that looks like a full or plenary guardianship where one person or sometimes 2 or more people are given all of the decision-making authority over the person under guardianship. We don't really like to say ward these days, even though it's still the term in some statutes. People find it offensive, and we do want to be as respectful of people as we can. But sometimes guardianship is taking away all of an adult's decision-making authority. Other times it's just some. And that's called things like limited guardianship. Usually the term for it, though again, there's a lot of jurisdictional variability. Guardianship is an issue of state law. So every state can do things differently. Guardianship is often treated as the default for people with intellectual and developmental disabilities. It's also pretty common for people with traumatic brain injuries, especially significant ones, older adults who have exhibited cognitive decline. And in some states, guardianship is even something that state law offers when someone is struggling with substance use. So now we know what guardianship is. It's decision-making authority moving. Let's talk for a second about what it isn't. I don't know of any US jurisdiction where guardianship is a guarantee of safety, having enough money, having good support services, especially HCBS, having access to good medical care, having enough food, having nutritious food, not going to jail or prison. It's not a defense, a protection, a safety net, really, against life's ups and downs and the troubles that we sometimes see affecting people. It's not some sort of protection that will keep something bad from ever happening to a person. It really just moves decision-making power from person A to person B. Since we're moving decision-making power when we contemplate guardianship, when we place someone under adult guardianship, it's important to remember that there are massive civil rights and dignity implications here. A full guardianship in many states strips someone under it of pretty much all of the substance of the normal legal status of an adult. This is often taking away someone's freedom to do things like make work and educational choices, decide where they're going to live, decide who they're going to spend their time with, decide what healthcare to accept and decline. And even have really meaningful say in decisions like whether to live in the community or in an institution. There's a lot of variability across the country in how guardianship is playing out, in who is allowed to be someone's guardian, in where people under guardianship are living and under what conditions. But at least in some states, there is definitely a guardianship to institutionalization pipeline. Another thing that tends, I think, to cut across the whole country is that guardianship involves a loss of control, not just for the individual, definitely mostly, primarily, most centrally for the individual, but also for the person's loved ones and natural supports. Guardianship is subjecting whatever arrangements and natural supports someone may have had to the local court system. I have often warned families that a lot of control goes away at the courthouse door. Various kinds of court personnel, as well as adult protective services or DSS personnel, depending on what state proceedings are taking place in, can have a lot of power in those proceedings. And they don't always do what the individual or the family would hope. We also have to consider that because guardianship strips an individual's ability to make legally binding decisions for themselves, decisions that others have to respect in the way that they do for most adults. If someone has an innate ability to protect themselves from abuse and neglect, guardianship can make it harder for them to do that, sometimes impossible, since it's just hard to take action when one isn't the legal decision maker in one's own life. And since pretty much no guardian can be there with eyes on the person 24/7, it can be beneficial to leave people with some capacity to resist abuse and neglect for themselves. Okay, I'm seeing a question from Patrick. I experienced visiting a resident at a nursing home with BTI who was stuck with guardianship. I attempted to contact the resident's guardianship numerous times, but no response, including a choice to get the resident out of the nursing home. Should there be a stipulation in guardianship laws that include a requirement to respond to and work with an independent living center in that area? I think that's a great question. Honestly, I think there should just be less guardianship. It's true that guardians are not always responsive to people who reach out and try to improve an adult subject to guardianship's quality of life and autonomy. Some are, but then again, some aren't. And low quality guardianship is a big problem. What I would propose, though, as the solution for most people is that people are generally better off in the driver's seat of their own lives. People without a disability label are not expected to make good decisions 100% of the time. I'm not going to ask for people to raise their hands and embarrass themselves, but really, whoever on this webinar has never made a bad choice should feel free to cast the first stone. There are other kinds of decision-making supports than guardianship. There is this increasingly favored approach called supported decision-making that some states are actually starting to legally codify and recognize. And it's born of the realization that people with disabilities want autonomy just as much as anyone else. Now, it may sometimes take more effort and more accommodations, communication supports, extra time to explain, simple language, a trusted helper being there, cool down time in stressful situations. But increasingly, what a lot of advocates, particularly people with disabilities ourselves, hope to see is a world where there's less and less guardianship because we're giving people the supports that they need in that regard. Even when someone's got a limited guardianship, for reasons I'm sure everyone here can understand in terms of decisions being complicated and abstract and high stakes, two areas where it's pretty common to see someone with guardianship, even if they don't have it in other areas of life, are healthcare and money. Not hard to see why. But what if, instead of giving someone with an intellectual disability a guardian because some of the complexities of healthcare decisions are hard for them, we made sure that it was possible for them to have a trusted supporter with them at doctor's appointments, someone who would have more time than the doctor who has 15 minutes to sit down and talk through the options and the cost benefit analysis and give an honest opinion on what to do while letting the individual make the final decision. This is something that a lot of people in the world do, including people who don't have any disability label or any cognitive disability label. I think about my father, who's a successful professional who usually sends a millennial or Gen Z staffer to do it for him when he needs to buy a new work laptop. He hands them the options and lets them make the choice because he doesn't really know what he's doing, or he presents them with the features he wants, like what his priorities are, and gets help with something he doesn't really understand. Anyone who has bought a house and used a realtor and an inspector and maybe even a structural engineer in that process has some experience with the concept of supported decision making. We've got a comment from Tanya Morweek. California's SB 1663 is working toward creating access tools and supports. Yes, it would be great to see California joining the growing number of states that are trying to recognize this. Peggy Martin says many folks without guardianship have medical or financial POAs. Yes, that is a way that, especially in states that haven't codified supported decision-making, such that people can do legally recognized supported decision-making agreements, the way that they codify it is through POAs. And for individuals who meet the capacity requirements in the states where they live to do a POA, that can be a great option. Important to talk to a lawyer in the relevant jurisdiction if there are capacity concerns. And I have never run into this in the real world myself, but I have had a lot of encounters with people who say that banks in particular can be finicky about people who use POAs other than their own standard forms. So there are some logistical considerations there, but those can be great tools. Here's a comment from Tanya again, or a question. Hello, can you recommend some supported decision-making tools that states can access to better pursue alternatives to guardianship? We find that targeted tools for specific entities like schools, med entities, and judicial circles are important, as well as case studies with lived experience highlighting alternatives. I think that's absolutely true, and you've identified really some of the ways that especially younger people end up under guardianship. Schools sometimes recommend guardianship to parents and are not really informed on the alternatives. Sending out informational resources through state departments of education to promote alternatives and talk about the drawbacks of guardianship, including the fact that in a lot of states, even limited guardianship involves being declared globally across the board legally incompetent, which is kind of demeaning and has collateral consequences, unpleasant collateral consequences a lot of times. For younger and older people, healthcare systems can be a driver of guardianship, and I think reaching out through medical boards, voluntary professional associations for healthcare workers, as well as hospital administrators, that kind of thing can be helpful. Anonymous attendee says, do you endorse supported decision-making or POA versus guardianship? I'm really here to talk about what guardianship can and can't accomplish. My organization is very pro supported decision making and finds that that is working for a lot of people. POAs can be a way to do it and can be a way to do surrogate decision making that functions almost like guardianship. They're complicated. All of this is highly individual, and I can't speak to specific situations. The Solution Center says a big problem is school systems advising parents to get guardianship over their children before they turn 18. That is a place that needs education. Agreed. And I think reaching out through both formal state government channels and also associations of educators can be really useful for explaining that guardianship's not the only way. It comes with drawbacks. And also, like, teachers and school administrators should probably not be the ones handing out legal advice. Hillary Kaplan says, I belong to a group called US for Autonomy. We advocate for people with disabilities to make their own end-of-life decisions. Would guardianship preclude this ability? Again, that would be situation specific. Some states might choose to provide for assisted suicide very separate, like in a separate, different way under state law, or might do some sort of carve out. But as a general matter, a lot of guardians have power over medical decision making, and unless a specific state statute provided otherwise, that sounds like it would probably be a medical decision. Tanya, again, are any financial institutions working with financial literacy or ed for people with disabilities, extensions of financial empowerment? I don't know of any, but I certainly don't know everyone out there working on disability issues. And I think that would be wonderful. Along with the autonomy and guardianship questions, the disability community just has a poverty problem on the whole, and anything that could be done about uplift in that regard would be a beautiful thing. Marina Martinez McKinley says, hi there, I came on a few minutes late. Is there a list of objectives that will be met in today's session? I didn't bring one. I try to keep these very open and conversational. Theresa Stimson said, can you provide information regarding what states have codified support persons legislation? I don't have a full list off the top of my head. That's a really good question, but I can try to get a list and send it to the organizers. And if there's some kind of email that will go out when this is over, hopefully get that included. Nisha Baiju says, love this info and bringing it home. So true, as many of our parents are getting older and we are in the sandwich generation. Yes, this is something that has implications for people with disability labels throughout our lifespans, but it has implications for a lot of people who will live to be old. Anonymous says, can a POA make medical decisions on approving or delaying the start of state services, such as for caregivers, or if this is something that is not included in their power as POA for medical, would guardianship be needed for something like this? That would depend on a lot of different factors. It would depend on state law. It would depend on what powers a hypothetical POA gave to an agent. If that is a specific situation that's come up in your life, I highly recommend that you talk to someone licensed in your jurisdiction about it. David Bernstein asks, is power of attorney an alternative to guardianship that is a bit less restricted? Good question. This is an issue of state law too, so there's a lot of variability. But in general, POAs are different from, but sometimes kind of overlapping with guardianship, especially springing POAs. So springing POAs are what most people use. Like, I have one as part of my own estate end of life planning. And I think it's good for any adult who is not under guardianship to do their research, talk to an attorney licensed in their jurisdiction if necessary, and be sure to make the appropriate provisions for the state that they live in, so that someone could make decisions if a situation ever arose where they themselves couldn't. So POAs, someone usually has to have a degree of decision-making capacity up to a standard that lives up to a standard set by their state to make a POA. That is not always the same legal standard for whether someone is eligible for guardianship or not, but a lot of times those things are close. In most states, when a person is, pretty much any state, I think, when a person is at the point of being eligible for guardianship, they're no longer going to meet their state standard of capacity to make a POA. So POAs are a great tool when a person can meet that standard, which is a lot of people, even a lot of people with significant disabilities, can meet their state's standards for decision-making well enough that POAs are a workable tool, though sometimes when someone has a mental health disability or an intellectual disability label, doctors, financial professionals, and others may question their decision-making capacity anyway. And POAs are a really great tool for, in many jurisdictions, for staving off the need for guardianship in the event that someone experiences cognitive decline or gets a TBI, because they can avoid the problem of decisions need to be made and nobody has the legal authorization. Tom Mullen says a good CIL should have access, to the services, resources, and peer support to mitigate most guardianships. CILs are the preventative answer to the rethinking of guardianships. That is hopefully true. There are a lot of services that can be alternatives to guardianship. For some people, very basic things like a second signature bank account, some services and supports, or some communication tools to make sure that they can make what they want understood to others are enough to let the person avoid guardianship and remain in the driver's seat of their own life. Anonymous says, I think there should be some clarification about the fact that a POA generally requires a level of capacity. Conversely, in a situation where there is a guardian, it has been determined by a court that the person does not have capacity. Yes. As a general matter, POAs are not going to work in situations where people already have a guardian, unless the person is a candidate for restoration to competency and gets restored. I don't know of any state where someone under guardianship could appoint a POA. Jim DePrado asks, is guardianship permanent? A lot of times, usually. I wish I could say more about that, but we don't have great data on guardianship, which is kind of scary when you think about how many civil rights it takes away. There are estimates. probably most people under guardianship don't get restored to competency and put back in the driver's seat of their own lives. And one thing that a lot of advocates are trying to do is they try to pass new guardianship statutes in their states and enact some reforms, is to get rid of the presumption of permanence and make it more possible for people who think that they're candidates for restoration to get out of guardianship, including giving them legal representation if they want to pursue that, which is a big problem. Anonymous says, is there a list of states that have supported decision-making? Also, if someone had a guardian, how can they switch it to having supported decision-making? I haven't seen a whole lot of information about how to go about getting supported decision-making instead of guardianship. There doesn't seem to be much info out there, at least not that I can find any advice. So Anonymous, I'm going to try to send around a list. It keeps changing. This is a growing movement and more states are passing legislation. So I don't have who has done it off the top of my head, but I'm going to try to send that around after. In terms of switching from guardianship to supported decision-making, that's hard. That's a process. It's much easier to implement supported decision-making for someone before they have been adjudicated than after, because once someone has been adjudicated, to truly give the individual the power over their own life back, the basic decision-making authority that most adults have back, a court would have to undo the adjudication, which I've represented people in those proceedings in my home state. It's a process. It can be done. One of the reasons that it's not more commonly done is that a lot of people with disabilities are poor, and even those who aren't, if they have guardians, generally don't have control of their money. So it's very difficult for people to hire lawyers, and it's hard for anybody to get restored. It's labor intensive. Even I was lucky enough to be able to help people with it while working at a nonprofit where I could take cases that made no financial sense and work hard at them for months on end in a very individual way, go out into the communities where people lived and talk to everyone they knew and round up all the evidence that was needed. And it was still not easy to end a lot of existing guardianships. We would need much more widespread access to counsel in guardianship proceedings, kind of like a public defender program, which is something that my organization wholeheartedly supports. I support personally. I just don't. The average person doesn't really stand a chance in high stakes legal proceedings about their basic freedoms, not represented by counsel. And I think it's a no-brainer. Just like we give people counsel in criminal proceedings, whether they can afford it or not, we should do it in these situations too, to give people, so that people stand a chance of protecting their rights. Anonymous says full guardianship is grossly overused and abused, more often granted without consideration of alternatives. This pipeline to institutionalization and further isolation is often a result of APS intervention and conflicts. In PA, the Department of Aging act in multiple conflicting roles like APS and ombudsman, as well as guardian. This is an example of your earlier comment to the lack of protection guaranteed or even accessible to people alleged to be lacking in capacity. Quite the opposite often happens. More exploitation and abuse and abuse without oversight and protections. Are you aware of many states having the same conflict with their Department of Aging administering these roles? I think a lot of state guardianship systems are well-intentioned. There have been some cases of people, including public guardians, stealing, doing horrible things, harming people. But I think most people in these systems genuinely want to do good. But there are a lot of states where the people who serve as the public guardians for adults under guardianship and APS are too closely entangled. There are roles within the court systems that get messy in terms of what interests someone is actually supposed to be representing. I think a lot of guardianship systems are messy and rife with conflicts of interest just because when they were being designed and built, the people designing them didn't always think like, we're taking people's basic rights away. There should be a ton of due process protections here. We should recognize these as adversarial situations, in some ways a lot like criminal cases. I just don't think that was fully thought through, and this was viewed as so paternalistic that a lot of really problematic structural things were overlooked. And yes, I think those problems are pretty common. Maria says, is there a list of agencies in Illinois that would assist someone to learn more about legal guardianship? I don't know Illinois that well, but I know that you all have a very robust protection and advocacy system. I would Google protection and advocacy system, Illinois, and try to get in touch with them. Peggy Martin says, wouldn't advance directives help in some end-of-life situations? Sometimes they can be helpful. It really, again, depends on the state, depends on the situation. Thank you, Sarah. Sarah says, here's a link to a website to find information about SDMA in different states. I'm going to take this, and is there a general chat I can put this in? Let me see, to make sure it doesn't disappear now that I've answered the question. Oh, here it is. I've tried to use the chat lightly because I know, yeah, it can be disruptive to some screen reader users, but hang on to that link and hopefully it can be emailed out after the presentation too. Dr. Nancy Foster says POAs can be specific, like medical or financial, etc. Guardianship is all or nothing, correct? So thank you for this question. Depends on the state, like all of this. But in general, a lot of state courts have the power to make guardianships limited as well, which means that they might just be about one or a few areas of somebody's life. The difficulty is that in a lot of states, for someone to have a guardianship, even in one area, let's say money, in many states, for someone to have a guardianship in even one area of life, they have to be declared across the board incompetent, which, depending on state law and policy and practice, a guardianship in that single area could have implications for stuff like right to vote, ability to get a driver's license, even if the person can drive safely, and just in general, whether how seriously the person is taken in the community. It has implications for firearm ownership. So there are a lot, what they are depends in large part on what state somebody is in, but guardianship, even in only one area of life, even leaving the person with a lot of decision-making authority, can have really nasty collateral consequences that have an adverse effect on someone's lives. And this is a big part of why my organization favors using the alternatives when they're at all possible and really making guardianship a last resort, and frequently reevaluating when it's been put into place whether a less restrictive alternative has come along that would work for the individual. Anonymous says Indiana has the VASIA program through the state Supreme Court. This is adult guardianship. This program requires volunteers to spend time and put eyes on individuals, go to care plan meetings, and advocate for the individual's wishes. The program plans events for individuals at the facilities where they live. They ensure that they have clothing and the things they want. They have successfully gotten guardianship removed from 3 or 4 individuals and do a great job before going to court, finding family and all other options. They also have reports for the county courts and the state courts. There's actual accountability in this program. That's exciting to hear. I think a lot of interesting approaches are being tried around the country, and I've heard good things about Indiana specifically. So that is a sign of what can be done, how much room for improvement there really is. Anonymous says, where would someone find resources about pursuing supported decision-making versus guardianship? Would the court system be involved with supported decision-making? There are a lot, like a growing number of resources that can be found online. The American Bar Association has some of my favorite materials on this. Some other organizations have information as well, a lot of protection and advocacy systems. And for everybody in the US, there's a protection and advocacy system for every state, every territory, and Native American nations. Google your jurisdiction plus protection and advocacy system. They may have resources as well. And if they do, theirs may be specific to where you live. They also sometimes provide free legal services and technical support. So always worth reaching out. Would the court system be involved? Depends on the state and the individual. Advocates who are really on the cutting edge of these issues are promoting less court involvement and more accountability through multiple people having eyes on, making sure that people are living in the community and have multiple supportive relationships so that it would be hard for any one person to exploit somebody without it being noticed by others. But people on this call without disability labels don't have to go to court to get their knowledgeable friends help buying a car, like talking through what car they might like. And the hope is to move in that direction, but different states are doing different things in terms of how involved the legal system is going to be with the alternatives. Jennifer Black Hands says, other than able accounts, what financial structures are available other than a guardianship or conservatorship account? When a supported decision-making model is utilized, can those financial structures offer sufficient protections for continued access to benefits, SSI, Medicaid, etc.? For SSI, Social Security benefits specifically, a lot of people who are pursuing the alternatives just have a rep payee if they need one. Some people have found that joint bank accounts with spending limits per day or to certain locations, things like that, can be good for people who struggle with managing money, who are trying to pursue alternatives to guardianship. There are some tools out there that are specifically geared toward people with disabilities in that regard. It's worth digging around online. This is a problem that people out there in the private market are trying to solve. For some people, joint bank accounts or dual signature for purchases over a certain amount type bank accounts with one or more trustworthy people, or auto pay for bills work pretty well. Anonymous says volunteer, advocate advocates for senior or incapacitated adults. I think that's a great model in some ways, because more eyes on can only, like, strong relationships, someone who will speak up and encourage the individual to speak up if there's abuse or neglect or exploitation going on, is wonderful in terms of keeping vulnerable adults safe and well. And social isolation isn't good for any of us. At the end of the day, though, once somebody is in actual court proceedings that affect their rights significantly, I want them to have a lawyer. Maria Martinez McKinley, where can one find the state standards? Depends on the state. Some are better at posting things online than others. Worst case scenario, a protection and advocacy system or a lawyer can probably provide information. Looks like Sarah has another good resource that it would be good to share in the general chat. Tanya says, totally lack of data, any info on racial disparity, age of guardianship, onset. I cannot find it. No earthly idea, and it terrifies me. Like, that's something that I really worry about. Others at my organization worry about. I think we should know that. There was a bill that I think Senator Casey of Pennsylvania introduced that would do something to address that, and we certainly wouldn't mind seeing it pass eventually, because the lack of data on something this intrusive is really, really frightening. David asks, how does succession work if the guardian is unable to fulfill their duties? Depends on the state. Every state has a different process for this. And if you've got a specific question about this, you really want to talk to someone licensed in your jurisdiction. Lakeisha Jones says, when a guardian passes, does the client become free, or do others have a right to mandate the naming of another / replacement guardian? Very similar to the previous question. Again, depends on the state. And it also depends, like, in practice, in every state in theory, in every state I'm familiar with, once somebody has a guardianship in that state, they have a guardianship in that state until a court says otherwise or they die. But there are states where someone who has a guardianship that isn't over money, which is pretty common for people with IDD who don't have assets other than Social Security benefits. People in that situation may end up with a guardian of the person and a rep payee, but no guardian who handles money. In some states, people in that situation never go back to court. And if a guardian dies and the court never happens to find out about it, the person has still been adjudicated, but no one specific is guardian, which would be a problem. Nilanjana Molik, are there any financial resources that could pay for legal costs for guardianship in Maryland? None that I'm aware of, but I don't know much about putting people under guardianship. It's really something I try to avoid. Tom Olin, easier to have restoration under supported decision making. If what you're saying there is that courts like people who are seeking restoration to have a plan, I wholeheartedly agree. I have found that when one goes to try to get someone restored, the court will tend to have a lot of questions about safety and about how someone will deal with any gaps in their decision-making ability. And I have found it extremely helpful and anybody listening who is a lawyer and might think about taking on some of these cases, if there's anyone like that on this call, I have found that it works better when the individual is honest about their limitations, willing to be very frank about that, and can demonstrate to the judge, and sometimes there are juries in guardianship cases in some states, whoever the decision maker is, that there's a plan in place to deal with those limitations in a way that's going to be safe and trustworthy. Tanya has some great links. If we can share them, I think that would be good. LaTanya Smith says, I may have missed this, but does a minor come under guardianship? Different states handle this in different ways. It's not something that I know much about in terms of the non-disability related. Somebody needs to make decisions for a minor, and it's not going to be the biological parents, either temporarily or permanently, aspect of this. But there are some states, certainly this was true in North Carolina, that allow someone to petition to seek guardianship when someone with a disability is about to turn 18. Ben Blackman says, my son, who is profoundly autistic, will be 18 soon and will need a conservatorship here in Tennessee. His mother and I are divorced and get along really well. He lives with me full time and has for most of his life. I was going to apply to be the conservator, but I would want his mom to step right into that role should anything happen to me. Co-conservator, any suggestions here? I understand this may be state specific. I will likely hire an attorney, and I'm wondering if there are any specific things I should ask about. It's not just state specific. It's like you're asking for legal advice. I can't answer that, but that's a good, succinct explanation that whoever you hire to tackle this for you is really going to appreciate. Seems like you'll be an easy client for someone. Anonymous says, what can APS do in lieu of obtaining guardianship in order to have someone with autism, mental instability removed from a family home for aggression and placed in a group home or other residence? For example, POA for medical, financial, property, or other. That sounds like a really challenging situation, but also very specific and individual, and not something that I should wade into. Jim DePrado says, my child is 17, has ID, nonverbal autism diagnosis, and I and my wife make every decision in his life. I believe he is all there, but very immature. He can't even communicate when he is in pain, but or what he wants to eat. Clearly, we need something going forward, but someday we won't be here. He's so young, hence my permanence question. How are situations like this usually handled? Right now, like, that is a very specific question. I think you should talk to a lawyer licensed where you are. I will say, as a general matter, for people with ID, especially people who are non-speaking, guardianship is treated like the default right now. I hope we can develop better and better tools as the years go by to make that not necessary. I'm going to look through real quick for anyone I don't think I've answered a question from before, because I am so sorry. I appreciate the extent of the conversation. You all have some great questions. I just do have to go right at 3. Sarah asks, is there a list of things or areas that are impacted by guardianship? Every area of life for the people affected. Andrea Bartels-Ham shares a link. Steph says, what is the difference between a guardianship and a conservatorship? What terminology state statutes use in a particular state? That's the only difference. Since this is a state law matter, we do see different terminology across the country. Maria Franco. I'm currently assisting an individual to handle his money. The bank provided him with an ATM card, which does not allow overdraft. Yeah, there are a lot of financial tools out there in the world that are working really well for people. Thank you so much for sharing that. So maybe we'll take one last one. With the guardianship / institutional pipelines, doesn't it seem a violation of the ADA Olmstead most integrated, least restrictive mandate as it relates to the lack of consideration or access to federally mandated CIL advocacy or transition services? I think there are some really interesting questions in states where there's a strong guardianship to institutionalization pipeline about whether there are Olmstead violations there. Because at the end of the day, even when someone has a family guardian, this is all happening under state authority. But those are questions that ambitious lawyers are going to have to answer on a state-by-state basis. And I really look forward to seeing the outcome.
Larkin, thank you so much for joining us today. I know you have to jump off here very quickly, so I want to make sure that we really let you know how much we appreciate. This has been a fantastic session, a fantastic discussion, and we just want to really thank you for joining us today. And I think our final slide has just a couple of reminders for folks about some upcoming sessions. On June 21st, we have a session about inclusive hiking. On July 12th, we have a session about beach access. And coming up on July 19th, we have our all-day mini conference on ADA employment basics for people with disabilities and those who support them. So check our website at adainfo.org for that. And thank you all for joining us this afternoon. Thank you to our speaker, Larkin. Thank you to our captioner, our interpreters, and enjoy the rest of your day.